Good morning, everyone. We're really happy that everybody could join us today. We have an exciting webinar in store. As you know, we're here to talk about Tarion issues, and we're here to talk about performance audit. And we are very privileged, honored, and excited to have two amazing panelists with us today. So we have Christy Allen from Davidson, Houle, Allen Condo Law, Steve Christison from Keller Engineering, and thank you both for taking the time and joining us, and welcome.
Hey, hello.
So we're excited because this is our first webinar in this series. We're looking forward to doing one a month with a different topic, so it's exciting for me to have you here for the first one today. So let's start by relaxing things a little bit and asking you guys how your weekend was with long weekend and crazy snow.
How did everyone enjoy shoveling, especially when your snow blower breaks? It was a lot of shoveling. I think it's all I did this weekend was shovel, carry a kid to hockey, shovel again.
Good cardio though.
Yeah, pretty much. I didn't get a heart attack, which is good.
Oh, good. Okay. Christy, how about you?
I was working out in the same way, shoveling, and also spending time at hockey rinks. So a very Canadian winter family day weekend.
That is for sure, yeah. So hockey generally wasn't canceled?
Ours was the only one not on Sunday. We got a call from the other team on the way in saying, hey, we want to cancel. We said we're 3/4 of the way there, so please show up.
Everything else may come to a grinding halt, but hockey shall go on. This is Ottawa. This is a good thing. Yeah. So in talking about performance audit and Tarion warranties, one of the reasons we wanted to talk about that is because right now we're kind of in the middle of the winter. We're in at a point where for most new builds, there is still some activity happening, whether it's interior activity that's taking place or whether it's deficiencies that are being addressed that can be addressed inside a property that's been newly built, but not as much activity this kind of year as we would start to see as soon as the spring arrives. Typically, that's when deficiency correction by developers really takes off and they go full pin, building envelope issues and water penetration issues and any of those things. So we thought with this downtime right now, a good time to talk about it. Everybody can get educated and then make sure that we're prepared when that big rush hits in the spring for everybody to know their roles and be doing what they should be doing. So I thought we would start with just a brief overview of Tarion and what the roles are. So maybe first we can talk about the Condo Corporation, the Condo Board, and the Tarion designate that would represent the Condo Corporation. So Christy, maybe starting with you, what do you see the role of the Condo Corporation being in that Tarion process?
In terms of the condominium corporation's role, it's largely going to be led by the board. The board will have appointed Tarion designate as its representative for the purposes of communications with Tarion, but the board itself is going to be involved, as is the manager, obviously, in the process. Generally speaking, boards are pretty aware, or sometimes boards will designate certain members of the board to sort of lead the charge on the Tarion process, but generally speaking, in my experience anyway, the boards are relatively well aware of what they're dealing with in terms of the deficiencies that have been claimed to Tarion and the process that unfolds as part of that process.
Right. Yeah. So important that that the board is aware of those things, and like you say, typically they are. Boards are aware of how important it is to make sure that process from the Condo Corporation standpoint is done right. You get that one kick at the can. If it's not done right, it can affect the property and the building structure for the life of the building structure, and it can certainly have a huge financial impact on the Condo Corporation as well. So then looking at perhaps the condo property manager's role in that is typically that the manager is a conduit. If the manager is not the Tarion designate, which sometimes they are, representing the condo corporation, then the role of the property manager is really the conduit between the Tarion designate and the board of directors, and in some cases between the contractor and the board of directors, making sure they're communicating things properly to the board so the board can make decisions, and then making sure that they communicate properly with unit owners because often access is needed to units for the developer to be able to carry out certain deficiencies. So that communication is really important, making sure that the important aspects of communication are covered, that it's frequent enough so that the timing is right, that the vehicle of communication that's used is the right one, and that the content of the communication. So we always talk about communication, right? And from a property management standpoint, we always talk about how important that communication is, but sometimes we don't define it enough. Because if we just say communication is vital, that doesn't mean that all communication is vital. It doesn't mean that all communication is valuable. So I always like to say, let's make sure the communication is not just about volume, but the right amount of communication at the right time, right content, and using the right vehicle. Anyway, I'm on a communication tangent, but we'll bring it back to the role of the developer. So let's talk about a little bit about the role of the developer, the role of the builder. So we have a property that has been built. Let's say it's close to being finished. There's still some work left to do on it. What is the developer's responsibility, Steve, when it comes to the Tarion process?
So once they've turned the building over, they obviously have to complete the building. But once they get the initial performance audit from the engineers, they're basically going to be given a list of here's everything we need to do. And they work on what's called the PATS, or the Performance Audit Tracking System, which is a part of the My Home website that Tarion supplies. But basically, it's a way for the developer to communicate with the board on the status of every one of those defects. And that could be anything from, hey, I'm going to fix it. This is my plan. I've done it, to we're not going to warranty it. And basically what they have to do is every single 90 days, they have to keep updating that PATS portal to ensure that the designate knows what's been going on. And in the same case, the designate needs to also fill up that same PATS every 90 days to make sure that that process continues on, with the idea of everything being resolved within 2.5 years after declaration.
Right. So, and maybe that's a good jumping off point to talk a little bit in detail about the PATS, so the Performance Audit Tracking System. It's accessible through the Tarion website portal. So the Tarion designate for the condo corporation gets a password and login information after they have to send in their designate form and notify Tarion that they're now the designate, and then they'll get access to it. And then the builder has access to that. And the idea is they should be updating those. I think the minimum requirement is 90 days.
90 days is supposed to be,
yeah. So that's but let's be clear, that's the minimum requirement. And I think if it's only done 90 days, we often see some issues with respect to the communication because it might mean that somebody's not addressing something, unless it's an issue, that's only accessible during summer months. Then you're going to have a gap of time where the last update is made, and there's not going to be any more after that. I've sometimes heard from people that the PATS, it's really a glorified spreadsheet that's kind of
originally that's exactly what it was. It was Excel spreadsheets being passed back and forth between the developer and designate. Yes. Literally just dates going back and forth. So yeah, it is a glorified spreadsheet, but as Tarion's kind of developed out more, it now lets us put in photographs to give status of what repairs are. It lets you have notes. It gives you a version history of what things are. So sometimes a spreadsheet is still the correct tool to track something, and that's kind of the case with the PATS.
Mm-hmm. Mm-hmm. Yeah. So, I've heard sometimes comments from people that it's a little bit cumbersome to deal with, or it's not great. I've never really experienced that. I've found it's been fine, and it's pretty good in terms of you enter the information and it updates, and that information is now live and available for the parties on the other side.
It's I've had my issues with it personally, but that's more of on a higher level trying to sort. And Tarion has been consistently improving it, so it is way better than it used to be. So yeah, I can see when it's cumbersome if you have 1,300, 1,400 items, which sometimes that's the case with these. It's just the platform sometimes isn't like making it easy for you to work when you're on that scale. But like I said, it does its job at the end of the day.
Yeah, for sure. And I think volume of items that appear on the paths and managing those is something we're going to talk about in a little bit as well, because it's come up as a contentious issue, but an issue that some parties feel needs some attention. We wanted to talk about really important dates, milestones that need to be met along the way during the process. And Christy, maybe you can fill us in on that.
Sure. I guess there's the obvious important deadlines, which would be the deadline by which claims have to be made. So Tarion provides 3 types of warranties: a 1-year warranty, 2-year warranty, and a 7-year warranty. For condominium corporations, those claims have to be asserted by the anniversary of the creation of the condominium on each of the first, second, and then 7th years of existence of the condominium corporation. So those are obviously important, because unless the claim is asserted within those timeframes, then there is no warranty coverage. So if a claim is submitted after the 1-year warranty that would normally fall within the 1-year warranty, it wouldn't be covered through the Tarion program. And so relief would have to be sought in a different manner as against the developer. Once the initial warranty claims are made, there's what's called an initial builder repair period, and that's 18 months following the 1st-year anniversary of the condominium's creation or declaration date. So at the end of that builder repair period, the 18 months following the first anniversary of the condominium, if there are still outstanding warranty claims that have not been resolved to the satisfaction of the condominium corporation has the ability to request conciliation. And this is the second most important deadline to meet next to the warranty claim deadlines. The request for conciliation has to be made within 60 days of the end of the builder repair period. And the reason that's really important is because if the request is not submitted within 60 days, the condominium is deemed to have withdrawn all of its warranty claims. So it no longer has any warranty coverage for any of the claims that it took the time and energy to assert, and maybe to follow the process for the first 2.5 years of the condominium's life. So that time frame is particularly important if the condominium corporation wants to pursue its warranty claims, which most of the time there are still some that are outstanding at that point in time. Once the request for conciliation is submitted, then the condominium can kind of breathe easy. There's a further builder repair period, and then there's the conciliation itself, which will take place 90 days or after. The further builder repair period is 90 days from when the request for conciliation is submitted, and then after that, conciliation is scheduled by Tarion. And I know we're going to talk about conciliation a little bit later, so I'll leave it at that in terms of the main timeframes. But again, they are the warranty timeframes themselves, so the deadlines by which the warranty claims have to be submitted, and then the request for conciliation timeframe, which takes place at the end of the builder repair period.
Okay. And so, again, just to emphasize that, the clock starts ticking when?
On the warranty claim process itself, it starts on the date that the condominium corporation is created.
Right. So registration
date.
So the date that's stamped on the front of your declaration.
Exactly.
That's the date that the clock starts ticking. So then it's 1 year from that date for the 1st-year warranty, 2 years from that date for the 2nd-year warranty items, and then 3 to 7 years from that date for the 7-year structural warranty.
Yes, exactly.
Yeah. Good. So obviously those dates are key, and making sure that we have a process in place, not just to meet those deadlines, but to get things filed in advance of that date coming. So you said that registering or filing for conciliation has to take place within that 60-day. Is that a 60-day window, or can you file for conciliation earlier than that if you wanted to?
The way the process works right now, you can't file earlier. My understanding is that that is being reconsidered because it's such a tight time frame and such severe consequences if you miss it. But right now, you have to submit the request for conciliation within the 60-day window.
Okay. So something that they might, are they maybe taking a look at it in terms of there's actually draft legislation that's in place to address it, or just it's kind of being talked about?
It's part of a consultation that Tarion is engaging in with the public, considering changing the way things are done. It's a relatively rigid process right now, but part of it is to prevent a situation where you may have multiple conciliations for different types of claims. So the idea right now, the way it's been established, the way the system has been set up is all sort of funneling every single claim made within the first and second year warranty timeframe into a single conciliation. And Tarion, I think, probably wants to avoid having a situation where multiple requests for conciliation can be made at different points in time, leading to various conciliations for the same property. Mm-hmm. So how that's all going to be reconciled, I'm not sure. But yeah, right now it's a 60-day window at the end of the builder repair period that condominiums have to submit that request.
Right. Yeah, and I think one of the things we can take away from that is that we're far from a perfect process. There never will be a perfect process, but we're far from one right now, and so it's good to hear that there are ongoing changes and updates being made to it right now. Let's talk about the performance audit itself for a few minutes. So this is obviously a really important document. It is the Tarion warranty process that is sort of driving or creating the impetus or the need for that performance audit report to be done. But the document itself is vital for the corporation. From my standpoint, I'm not sure what you think about this, Steve, but even if the Tarion warranty process didn't work, the performance audit's still really important and should be done even if that process didn't work. So tell us a little bit about that performance audit. I know you've done many of these. Keller's done many of these. So tell us a little bit about that performance audit, how it's done, how detailed is it?
So in short, it's basically your engineer / your architect going through your entire complex, examining all the common elements and trying to find every single construction deficiency or even potential construction deficiency. And the way we do it is through a couple different steps. The first part is there's usually a survey sent out to all the owners. And this is just asking some very generic questions such as, hey, do you have cracks somewhere on your balcony? Have you ever noticed any water leaks anywhere? Have you seen any just general problems? And the purpose of that unit survey is to, well, Mark was talking before, you had the massive communication. That's what kind of it is. It's just, here's your chance to let us know everything. The problem with them is a lot of times we do get everything. So it's to go through the shaft of to try to find those needles in the haystack is kind of the key portion of that unit survey portion. But a lot of times those unit surveys do kind of lead you to some of those bigger problems that your auditor will never see while on site. Something as small as saying, hey, I have problems with the air conditioning could examine into something being a major problem with the HVAC system. So that's that initial step, is to kind of get that feedback from the owners themselves, from the people who actually live there every single day, and get the what their problems with the building, what they've seen. Your auditor then will go on site and spend, depending on the size of the complex, it could be a couple hours to a couple days, to try to get a list of basically every defect they find. And what they'll focus on is on the common element areas. It gets very difficult to get into all the units just because of the how difficult it is to arrange it, how much time it takes to get to it. So a lot of those times, again, we rely on those unit surveys, but we really do try to find every single defect that we can find. Once we find that defects, we send the board basically the performance audit itself, which is just one large list of here's everything that we think is going to meet the criteria of what Tarion would consider a warranty. And like I said, that can be anything from some drywall cracking up to, oh, we found a major problem, say with the hydronic system or wherever else. And the part with it here is, again, it's just a list. So that drywall crack in that report is treated exactly the same way as you have to replace all the piping in your building, because to us, there were equivalent claims that we'll just have to go through the process after. So that initial list will be sent to the board. They'll have a chance to review it, have a chance to add additional stuff towards it, and then we end up submitting it before the first year anniversary. The first year performance audit is basically your standard everything. So it covers workmanship, it covers material and labor issues. So it's basically anything that we can think of usually goes on that first one. The second one, if the corporation decides to go ahead with it, is, which they don't have to by the act. The first one they do. But the second one more deals with water infiltration issues, HVAC issues, mechanical issues, as well as just kind of detachments and deterioration of the envelope issues themselves. So it's a much smaller list, but a lot of those ones are a much actually higher cost to the corporation potentially if we don't deal with them. And that's the whole purpose of these performance audits, is try to find all those while we can still deal with them in that early time of the corporation's lifespan.
Yeah, so really comprehensive document. And I know in some cases, specialty contractors might be brought in. I've had a specialty elevator investigative or consultant brought in specifically to analyze the elevator system and do a report specifically on that.
Yeah, so it's not uncommon that you request specific, especially if you know this is an issue. Like we have had full evaluations through infrared of all the electrical systems performed as some of these. You will have, like I said, the elevator consultant will generally come in because majority of the building envelope engineers or architects who provide performance audits, they don't have that specialty in-house. So we'll bring in someone who does have that specialty, is able to go into the pit and look at it. Part of that performance audit too is trying to identify those things that we may have to go spend a little bit more time to further evaluate. We may come across something where it seems like a single issue, but then we want to, because the performance audit doesn't really involve destructive testing by itself, we'll go find out, okay, we want to look into further because we found, hey, everyone complained about cold walls. Maybe we need to go punch some holes in some walls to go see what the assembly actually was constructed. Or we'll find out a whole bunch of people having sound problems. So we'll have to bring in a sound expert to go do the proper testing to make sure that it meets the proper Ontario building codes for the construction going forward. So the performance audit a lot of times is just kind of that first step. And there can be a lot of work that happens between that first year and even the second year. And as you're leading to your request to conciliation, while you're trying to tighten up everything that you kind of need to do.
Right. Yeah. And you know, sometimes there can be a little bit of pushback depending on the board of directors in terms of, you know, well, that, you know, doing that report or doing that investigation is going to cost, you know, $3,000 or $5,000. The reality is that if that's not done at the recommendation of the engineering firm performing the performance audit, if those investigations are not done, it could end up costing the corporation tens of thousands, hundreds of thousands more, depending on the seriousness of the issue down the road. So you know, it's a bit of a tough pill to swallow at first, but I think it brings to light the importance of budgeting, the condo corporation budgeting through operating costs. These wouldn't be reserve fund costs, but through operating costs to be able to perform those kind of tests. So budget, earmark a certain amount. And yes, it's going to increase condo fees or do it as a special assessment, you know, which is a word that boards don't like to hear, but the alternative is much, much worse for the corporation. So bite the bullet at the beginning, get the testing and the investigation done that you need to. Yeah. So as we move through the process now, we're at the point where we have the performance audit. Owner surveys are something that becomes an important part of that performance audit. And when owner surveys are done, basically, Steve, maybe you can fill us in. What's the idea of an owner survey? which helps us to understand what the unit owner's role is in the whole Tarion performance audit process.
Yeah, so the Condominium Act actually spells out that we have to request unit surveys as part of the performance audit. And the whole thing is, again, to get some information from the unit owner, especially for areas that the consultants who are doing the performance audit or the auditor just can't get access to under normal circumstances. So, and like I said, it's further, that unit survey helps us to, on some of the operations of the building, where some of the questions might simply be is just how's your heating and how's the water temperature in your unit, which you'll never get within a site visit, right? So that unit survey, and that's why it's so important for the owners to fill this out, is because a lot of the times those little tidbits of this happened on this date is enough to get your auditor onto a track that may bring them to a very different conclusion at the end of the day. Yeah.
And so we were gonna talk about perhaps the volume of items that end up being on the performance audit, and it does make the performance audit tracking sheet, the PATs, more and more cumbersome. Absolutely, as those items get added and the number of them increase. And sometimes there's a little bit of pushback from developers, from builders, to say, you know what, we want the corporation to vet those owner survey issues because we think a lot of them aren't valid. And I can understand that pushback to an extent. At the same time, maybe Christy, you want to comment on how important and why they're important, every one of those owner surveys and owner survey items that they decide to include.
Yeah, I can talk a little bit about that. I think Steve has touched on it, but from my perspective, so as legal counsel to condominium corporations, usually what I'm dealing with is situations where the condominium corporation has either lost warranty coverage or has been denied warranty coverage. And in those situations, I can say that what's included on the unit surveys can sometimes be the difference between warranty coverage and not. We have in the past been required to appeal Tarion's decisions denying warranty coverage on certain items. And what we end up relying on in the course of the appeal is what's contained in the unit surveys. Often what is contained there are descriptions of symptoms of problems, and then it's only later through engineering in investigations that we determine what was causing the particular problem or symptom that's indicated on the unit survey. But then at the appeal level or at the point in time where we become involved as legal counsel, we're able to rely on those initial claims. Basically, without the unit surveys, oftentimes the problems within the units or that are only observable within the units, as Steve has mentioned, are just not going to be included in the claim at all. And what happens where something is not included in the Tarion warranty claim is the condominium corporation is left with the only alternative to go to court. And that's a very timely and time-consuming and costly process. The Tarion process is designed to be faster and essentially cheaper to pursue. I can give you an example. We've been working on a file involving flooring deficiencies. So flooring problems at the subfloor level, so within the common elements that are only observable within the units, at the sort of manifests in the flooring. So obviously you have to be in the unit in order to see these particular deficiencies. The problems were reported within a few unit surveys, and in some of those cases warranty coverage was provided. But what we can do, as in certain, it depends on the circumstances, but in that case what we ended up doing was appealing Tarion's decision with respect to the balance of the units where this was not reported, but we made the claim that it should be warranted nonetheless because what we were claiming for was a common element deficiency. So the unit surveys effectively preserve the common element deficiency in all locations, even though it's only reporting for the specific unit location that the owner can observe. So it just makes our job easier at the end of the day when we have to pursue a remedy on behalf of the corporation. There are also times where Tarion will accept that at the conciliation stage. So often conciliation will take place before a lawyer is even involved. And if you're able to resolve these problems, deficiencies without lawyers' involvement, better for everyone. I hate to say it, but It is, because it's obviously going to be cheaper overall for the condominium corporation. And in some cases, Tarion has accepted that same argument at the conciliation stage as well, that if a defect is reported within a unit survey in one or two locations, it preserves that same defect that's discovered to exist either throughout the units or in more than just those one or two locations that were reported on the unit surveys. So they're extremely important.
Right. Yeah, for sure. And, you know, and I think that's one reason why, you know, owners will ask sometime, well, should I include this or should I include that? The answer from the Tarion designate, and I'm guessing probably from legal counsel and from engineering, is yes.
Yeah.
Yes.
Absolutely.
If in doubt, include it. And like I said, we get pushback a little bit from developers sometimes. And now the list is this long. Is it possible that a number of those items are not valid items? Absolutely.
Yes.
I've seen things included on owner surveys before that were simply exterior items that were not finished yet. It was the developer hadn't worked on that.
And that's actually a very valid point, though, right? The fact that it wasn't finished, it leads it to us to say that, hey, this wasn't actually a warrant. Well, they couldn't evaluate during that period of time, so it opens something else up to us. So actually, that is a very valuable piece of information.
Absolutely.
When something's not finished.
Yeah. And if I'm an owner, I don't know that.
Yeah.
Like what guarantee do I have that section of siding that's not on there just wasn't forgotten and left? I just know it's not there. So yeah, I'm gonna add it onto the owner survey. So definitely that lengthens the list that's going to be on performance audit tracking sheet. But it's in the best interest of the condo corporation, and it makes sure all of those items are protected. It's
very easy to resolve an item once it's on the list, especially if it's something where we can look at it. And we see a lot of these unit surveys where there's a lot of times some owners are very unhappy with what they purchased, and they will let us know during that unit survey that they are not happy with what they purchased. And many of those items will not be warrantable. They'll be included because maybe there is something there, but then it is not difficult after just to go through on the PATS portion and say, we resolved this. The developer will say it's not warranty. We'll agree and we resolve it, and it's just immediately off the list. But it's just way better to keep everything there just to protect the corporation in the long term, just in case there is that diamond in the rough there somewhere.
Yeah, exactly. And I think it comes back to first of all, the developer needing to be prepared for that, knowing that, there's going to be a long list. There's going to be a number of items. That's just
don't take it personally.
Exactly. It's just part of the game, and it's part of what you have to do to complete the whole process. But for the condo corporation as well, it's probably going to take a bit more investment on their part with their Tarion designate who they've hired, however they're handling it, with legal counsel, with engineering firm. To scratch those items off the list and understand, get to the point where they designate them as being not warrantable or warrantable. But like you said, a needle in the haystack or one diamond in all the coal, whatever it is, it's so important. And we've seen it happen where, there's been 50 things that an owner's listed on that survey. One of them not only has been valid, but has been a very serious issue. And perhaps other unit owners hadn't really noticed it, hadn't come to their attention, hadn't included it. But Christy, are we right to say that now that item is preserved for the rest of the units?
It depends on the circumstances, but certainly that argument is an available argument in a situation like that. Right. Yeah. I mean, ultimately, the performance audit process is based on observation for the most part. And if you have a whole building of people taking observations, you're in a better situation than you are if you just have, your analyst and maybe the board out there walking, or manager walking the property taking observations. I take your point that it does result in a lengthy list, but ultimately this is the very early stage of the condominium's life, and best to get those deficiencies resolved early. And if that means, as you say, investing time and resources into doing so, I think it's a worthwhile investment overall.
Yeah, for sure. So can I throw a hypothetical at you? I know lawyers love hypotheticals. So then if it's a hypothetical you don't want to answer, just tell me that. Just say, I need to contact my legal counsel before answering that question, Mark.
Okay.
So let's say I've purchased a unit in a building. My sales receipt, I forget exactly what that document is, but whatever that document is that I've purchased the unit and the developer has basically giving me a receipt. and it lists everything that I'm going to get. With my unit, it's going to list all the amenities. And in that list of amenities is a party room. I move into the building, no party room. I check in with other owners in the building, and one or two of them have a party room listed on their receipt, their document, but most of them don't. There's only a small handful. What happens with that issue? Is that a deficiency? Is that a warrantable issue? If it is, what can the Condo Corporation do about it?
Yeah, that's a really good point. Typically, the amenities are going to be listed that are promised by the developer contractually are going to be included in a schedule in the agreement of purchase and sale. But sometimes it's in marketing materials. Sometimes they're in a version of the construction drawings. Ultimately, if you were promised something on the common elements and it was not delivered, that's considered to be an unauthorized substitution or deletion from the delivery of common elements to you. So that is warrantable. And that's something that hopefully is part of the first year claim. But yeah, it can be pursued through the Tarion process. And ultimately, unlike a defect where Tarion can warrant a defect and the builder can repair the defect, it may not be possible to put a party room on the property, but it may result in a cash settlement as a result of the lack of amenity that you thought you were buying into and that formed part of the fair market value of your unit when you purchased.
Right. Yeah, the developers in a case like that, they're not going to be able to rip apart the building and actually install that, redesign everything. So we're looking at when we get to the end of the Tarion process, and perhaps we're talking about conciliation, which we'll talk about soon, is when that would be negotiated between the parties.
Yeah, and that's often something I know we're going to talk about it, but it's often something the builder will try to resolve with the condominium corporation directly through negotiation. But if it's not resolved that way, it can be decided by Tarion at the conciliation.
Right. Yeah. Steve, can we talk about Ontario Building Code for a second? So what role does Ontario Building Code play? Does it actually come into play in terms of the warranty process?
So at the end of the day, it's what Tarion really pushes to, actually. It's they'll refer to the Ontario Building Code, ask, is there actually an issue with the Ontario Building Code when I go through? On the first year, every Ontario Building Code issue is going to be warranted. The second year, it's more just on health and safety portions. But yeah, generally, that is what Tarion using as the guideline for whether something is a defect. They'll go back to it as, hey, does this meet code? Yes, potentially not warrantable. They have published the construction performance guidelines, which is kind of, if you have this condition, we consider it warranted or not. But yeah, really the OBC is what really the guideline is at the end of the day of whether something is warrantable or not.
So it is really important.
Really important. And so that's the stuff where you hope your auditor is referencing it if when there's cases where they are specifically is a break in it, because Tarion will flat out ask you, where's the OBC point saying that this is something wrong?
Right. And do you have to reference that in the performance audit, or is that's just something down the road that you would
if
need
it's
to
there,
reference
it's great. A lot of times they'll just simply ask you later, please give us correspondence dictating why you're saying this doesn't meet the code. Right. And that could be something as short as a letter or a little memo. So it doesn't necessarily need to be in the performance audit itself, but if it's something where you can easily point to it, it doesn't hurt to put it in there because it just stops the questions right from the beginning.
Mm-hmm. Right. Yeah. So as we're moving through that process now, we basically have three parties involved as we're moving through the process, right? We have the developer, we have the condo corporation, we have Tarion, the three main players. And it's obvious that by nature of the process, the developer is sitting on one side of the table and the condo corporation is sitting on the other side of the table. But I think for most of us, and you can let me know if you feel this is true, it's much better especially through the first 2 years of that process, if that relationship is not adversarial. Yep. If it is sort of a team mentality. And most of the time, in my experience, that works because in most cases, I'm not saying in all cases, I'm sure there are exceptions, but in most cases, developers want to deliver what they promised to deliver. So if you're bringing to their attention items that are legitimate deficiencies, Christy, in your experience, does the developer want to repair those, or is the developer like, I want to do the absolute minimum and I'm only going to do what I'm forced to do by Tarion, by the Condo Corporation?
It depends on the developer. I think there's a lot of developers in Ottawa that are pretty conscientious, and they're very responsive. They want to address the problems. I've worked with builders even outside of the Tarion claims process who have basically just owned up to the fact that there are deficiencies, and they come on site and they complete repairs that are pretty extensive. There's others that either deny that there are defects, or they attempt to repair those defects with caulking. Some builders seem to think 99% of problems can be solved with caulking. So it really does.
The bead can only get so wide, folks. Right?
That's when you use the double bubble after to fill up the rest of it.
You've probably seen that, haven't you? But yeah, it ultimately depends on the developer.
Yeah. So, as much as we're able to, I think having that as a non-adversarial relationship, and if the developer takes that hard line and isn't being cooperative or reasonable, then that changes things from the Condo Corporation's perspective, and it probably means legal counsel's getting more involved earlier on in the process. But if it can be worked through sort of as a team effort, everybody's doing what they should do in fulfilling their roles, then typically when you get to the end of that process, and now we're sort of getting in close to the conciliation portion, we're often left with a handful of issues. Hopefully it's a small handful, just depends on the property and the builder, but you're left with a handful of issues that we could describe as contentious issues. So let's say that that's what happens in our hypothetical situation here, and we move through and we have that handful of issues left. What position could the developer take on those? What position could the Condo Corporation take on those?
So often by the time you get close to conciliation, I think Steve can comment on this better than I can, because he's more directly involved in the conciliations. But in my experience, typically they're the bigger ticket items, so the more expensive items to fix, or the more extensive items to fix. I mean, the builder can take the position that it's not a defect, or I think more frequently the issue might be one of appropriate repair, proper repair. So the builder might think that a particular repair is okay, whereas the condominium corporation and its engineer don't agree. They think something more involved might be required. Ultimately, that's what conciliation is about. It's about having a third party make a final decision as to whether or not something is warrantable. And then there's a process to resolve differences of opinion with respect to the repair. Now, in more recent years, Tarion actually has the ability to hire an independent consultant to sort of break the tie, so to speak, when there's a difference of professional opinion on appropriate repair. So that's something that might be available to the parties if Tarion agrees to do that. But I know Steve has a lot more experience dealing directly with these issues than I do.
Yeah, so you kind of hit the head right there, Christy. It is really kind of the negotiation period by that point. So you generally are left with a handful of items, and sometimes it's the process really gears you towards that, where Tarion, through the pre-conciliation meetings that you're having leading up to conciliation, really are trying to put things into buckets, because you may have 100 problems with the balcony, but it's the balconies. Like, we know that's the problem. Or you may have small defects in the drywall or something. But then you'll have those big issues. And those big issues are the ones that's where your consulting money is probably going to go into, where those additional fees are. Because you're going to have your consultants writing up saying, we have to prove why this is a defect. They're going to have their consultants proving why it's not a defect. And you get into not so much who is right, but yeah, it's the proper way to repair it. And as Mark, you were talking about before, it's way better to not be combative with the developer, because you can then at least have those dialogues. So like you may come to a situation where you go, you know what, I would like to, if there was a waterproofing problem, excavate the entire garage and redo the whole thing. And their solution might have been, we just want to crack inject everywhere. And then you end up coming to a compromise of, okay, we can do the crack injections over here and we'll do what you want over there. And that's what that process really helps you get to, right? So you do kind of a compromise that's going to work the best for the corporation while the developer still gets to kind of get what they feel is correct too. So that's where you want to go through those processes. And I do generally find, especially here in Ottawa, it gets a little different where you are, that most of the developers really do want to act with the boards and the designate to come to a conclusion on everything. We don't have many cases where they just go, I'll wait for the conciliation, wait for the report, and then when it tells me to fix, I'll fix. But I'm going to do the bare minimum. That doesn't generally really happen here in Ottawa. It is usually very collaborative, even on those high ticket items, to come to the conclusion that everyone's going to be happy with at the end of the day.
Right. Yeah. So, and you know, that's been the experience, I think, of most of us who have been involved in the process. Is I mean, everything is relationships, right? It's business, and sometimes you have to pick your battles, and the corporation has to pick their battles. And I know I've had conversations with boards to say, you know, what the developer is recommending here for a repair is adequate, and the engineering firm has said is adequate. Is it the best possible solution? Maybe not, but it's adequate. And do you want to keep fighting that battle and become an irritant to the developer? And then that makes negotiating and coming to mutual decisions on how things are going to be handled that are maybe much bigger issues that could represent a much bigger dollar figure for the condo corporation. So you do, in some areas, have to pick your battles. So let's get into a little bit deeper into the conciliation process. So maybe, Christy, you can walk us through what is that process and how does it work when let's say we've now entered the first day of that 60-day window that we have for filing. What does the corporation need to do? How does the process work?
So I guess the short answer is the corporation needs to file the request for conciliation. The longer answer is that this is a period of relatively intense negotiation that happens with the builder. And so this is the period, like leading up to conciliation, that's the time frame in which the builder is going to try to reach an agreement with the condominium corporation that if it hasn't repaired the deficiencies that are going to be the subject of conciliation, then it might make a proposal to the condominium corporation, either a cash settlement or like, here's what we propose to do and the time frame in which we propose to do it, all in an effort to get the condominium corporation to sign an agreement, a settlement agreement that would result in putting off the conciliation. It's a complicated thing, putting off the conciliation, because you don't want to release your entitlement to conciliation. If you do need to fall back on that, if the settlement doesn't go through as anticipated, then you're going to want to fall back on that. So having there are certain areas where I would be the first to say don't involve a lawyer. It's not worth your money, but this is an area where you do want your lawyer reviewing whatever agreement the builder is proposing. Because it's going to be important to ensure that you're not releasing your Tarion claims. That's the last thing you want to do. And we would need to get Tarion's involvement and essentially agreement that the process is sort of going to be paused while this settlement agreement is the parties attempt to work through it and kind of come to a final resolution. If that doesn't happen, if the parties can't reach a settlement, then the process will, a conciliation will be scheduled by Tarion. And again, I know Steve has a lot of experience with some pretty lengthy conciliations. It really depends on how many items are going to be the subject of conciliation, but they can be just a morning conciliation or in some cases
over a year. It's not unusual. Like I said, if you start with 1,300 items, 2,000 items, they could potentially fix 1,300 items, but you're still left with 300. And what Tarion has to do during this process is they need to evaluate every single item. And I mean that. They will look at every single item that's left on that list. And that generally involves, and if you're a high rise, getting unit access to every single one of these, where you're having trapezing 10 to 15 people potentially through a unit to go show them, okay, there's a missing handle on this window. Yep, there's a missing handle on this window. We took a picture. We all left. Let's go do this over and over again. So the process can take a long, long time. But the good news is that process sometimes takes a long time. And so as Christy was talking about, that was initial 90 days of negotiations. There's nothing stopping the corporation from continuing those discussions during that conciliation process. So you can go through and say, okay, we're still having this one big item that we're discussing, but we can get these other ones and we're going to agree we're fixing this while they have the extension period on the repairs. What we've noticed since COVID has been developers want to do the work. They just haven't been able to get the trades or other workers in to meet the timeframes that Tarion's happen. So we've ended up having these long conciliation periods, not because we're in contention, but just because there's not the time. So we've been able to use that year-long period to actually mark off the majority of things on the list. So then Tarion's really only looking at 15 items, say, at the end of it. But yeah, it can take a long time to get there.
Right. And there's another option that's available that I've seen invoked in some situations where an agreement can be drawn up. So can you tell us a little bit?
Yeah, so there's also a repair agreement that Tarion lets you go through. Those are usually for cases, though, where you have a very specific scope of work that you're doing. And they don't want to do that when you have 300. They want to do that when you can keep it down to 10 items, right? Because then they can say, okay, I'm going to be fixing this balcony at this unit by this date. We are going to go waterproof this section of the podium, and will be completed by this date. And they'll sign off on those kind of things. So it's basically giving the corporation and the developer an extra period of time to finish the work. And if they don't finish it by the end of that repair agreement, the conciliation just takes back over again. So we'll have that conciliation during that point. Mm-hmm. I would say, at least here in Ottawa, they're not very common because generally we can't ever come to something where that straight repair agreement comes up to. We fit much more to a settlement agreement, which is more of a difference between, like Christy was going through, it's monetary amounts for items that we're signing off on. We're going to agree that some of these items are going to be fixed. We might be saying we're going to withdraw these other items because this item that we've never talked about during the performance audit wasn't even included. It's come up since. And the developers, you know what? They would go, we're willing to fix that. You can do that as part of a settlement agreement that you can't do as part of a repair agreement or through the rest of the process. Mm-hmm. So sometimes those negotiations, and again, that's why you really want to work hand in hand with the developer, because there's a lot of times that things that were just not included, they'll end up helping you with because you have that good relationship. And you may have said, you know what, I'm not worried about this one set of items because this other problem's become a much bigger thing. We can deal with that ourselves. If you help us with this, say a garage door that's not working properly, mm-hmm. or some other item like that.
Right. So from a legal standpoint, is that safe for the corporation to enter into an agreement like that? Is it like, will they get the same protection that they would if the conciliation period was extended instead?
So as part of that arrangement, we would possibly want to work with Tarion to see if we can extend the conciliation period until the point in time when those settlement terms are supposed to be resolved. So essentially it would mean that at the end of whatever that settlement period is, if there's still some outstanding items, the condominium corporation has the ability to go back to Tarion to conciliate on those items if they're not resolved.
Right. So it's not a matter of this being a separate legal agreement that's put in place outside of the Tarion warranty process. It's the end date on the conciliation period is bumped out to capture.
That's an ideal situation. It would require the agreement. Like this is sort of, we're talking about a process, or I guess an agreement that would fall outside of this, the Tarion guidelines and process. So we would have to work with the parties to ensure that everyone's on the same page in that respect. But I would say that, any settlement agreement that's negotiated in exchange for either not proceeding with conciliation or putting conciliation off should involve Tarion. And again, the corporation's legal counsel to ensure that you're not waiving any rights that you're entitled to.
Right. We've seen that being necessary in some cases where the cutoff period for the repair period is during the winter season, and it's an exterior item that needs to be replaced. So the developer says, yeah, it's no problem. We know it's a deficiency. We agree. We want to fix it, but we can't do it right now. So something has to be done in order to extend that and still protect the corporation for those items.
Those are the cases where usually the repair agreement usually happens. It's mostly those ones where it's just, we literally can't do the repair right now. We all agree we want to do the repair. This is a way to pause the process so we can actually do the time when we want to do it.
What incentive is there for the developer to actually make sure they get in and do those repairs and do them properly? What is the incentive for them? Or are there a few different incentives?
I'm sure there's more than one incentive, and would depend on the builder. From the Tarion perspective, if an item goes to conciliation and it's deemed warrantable, it's basically recorded as a chargeable conciliation against the builder, a warrantable defect. So these are recorded as a statistic, I guess, by Tarion, and that information is shared with the builder registry and made public. So it's basically if the builder can avoid conciliation, they can avoid having determinations of warrantable defects made by Tarion, which will ensure that their records are sort of kept more clean, so to speak. But I suspect there's other motivations, maybe some more strong than that for many builders in Ottawa anyway.
Yeah, interesting. The time has gone by really quickly. I did want to try and get to a couple questions that may or may not have come in on the chat. So we have a few. So first of all, before we do that, I want to give a couple shout outs to the two of you, but I'll get to that after. But also to John Doisman from IT Condo. John's been sort of the man behind the curtain here, helping us to produce from a technical standpoint. And John, maybe you could tell us what questions have come in. Pick one that is your favorite.
Oh boy. Let's start with this question from Douglas Baker. In your experience, what level of success have condominiums had going after developers for compensation when significant structural issues have occurred beyond the warranty period?
Okay. So that question again, what success have condo corporations have for pursuing the developer in what specific circumstance, John?
Structural issues.
Structural issues. So this was something that perhaps would fall within the 7-year warranty period.
It's probably more on you than me. We write the reports and say it's wrong, and then it goes into the ether until someone says we can fix it. So
yeah. If Tarion's 7-year warranty is also called the major structural defect warranty. And there's a definition for that warranty. So the defect, the structural defect, would have to fall within the definition of major structural defect. But I will say that we've had a number of claims that we've made to Tarion for within the 7-year warranty timeframe, and they've been successful. In some cases, sort of surprisingly so. We didn't anticipate that we would have success through the Tarion process, and anticipated we'd have to go through the court process. One thing to note with all Tarion warranties is that they are subject to a coverage limit. So for condominium corporations, it's either going to be a maximum of $2.5 million or $3.5 million, depending on the number of units in the condominium. It may not even be that high if it's a smaller condominium, but maximum coverage is $2.5 million or $3.5 million, depending on when the condominium was declared. For newer condominiums, it is $3.5 million. In some cases, we've exceeded the coverage limit, and so the condominium corporation has had to turn to the courts for the difference. But yeah, we have had success. Anytime there's a legal claim made, whether through the Tarion warranty process or court, it depends on the details, and it depends on our expert evidence that we get from our engineers.
We do get commonly asked, is this a 7-year warranty item? And it is the major structural defect definition is very small in terms of what it is. Basically, at least the way we've always seen it is, if it's not failed, you almost don't meet the requirement. So if it's something, like I said, it doesn't ever hurt to ask your auditor, do you think this problem we've had in year 3 to 7 will fit it? Just don't be too surprised if they say we don't think so, because it is a very small definition what would fall under that warranty coverage at least.
Right. Yeah, and I would add to that, just sort of as a side point, that that's an area where obviously engineering services are going to be vital in terms of doing the investigations and being able to build the case basically for the condo corporation to say this is a warrantable item and this is how it needs to be addressed.
It is probably the hardest one to prove by far.
Right. So obviously engineering services involved, vital, but it's also the area where I've seen like really valuable for legal counsel to be involved, because legal counsel can say, based on their experience, well, we've seen this kind of issue pursued before and the condo corporation hasn't been successful and here's why, or we've seen it pursued before and the condo corporation's been very successful and here's the body of evidence that you have to compile and put together. So I've always advocated, and I still do for my boards of directors, get legal involved right at the beginning of the process. Have one meeting with legal right at the beginning of the process, and get legal to advise and make sure they'll remind you of all the dates, the deadlines you need to meet, a number of other things, and get them involved. Get them a copy of the performance audit. They're going to know the major issues that they're dealing with. And then if the right players are involved, the Tarion designate is good, you're going to work through that process and you're going to probably not need a lot of legal counsel time through that process, depending obviously if there are some serious issues or contentious issues or whatever it is. And then most often what happens, if that part of the process goes as we hope it will, then legal starts getting involved more again toward the end of the process. Anyway, that's what I've found works really well. And then obviously engineering services are involved all the way through working through that process. Thanks, Douglas, for that question. A good one. Can we take one more? Where I know we're 4 minutes over time already. Let's do one more. Okay.
This one from Scott Broman. Is it recommended for a condo to have a Tarion designate, or would it be fair for this large task to be assigned to the condominium manager?
Oh, okay. Maybe I'll address that first, and then I'll throw it over to you guys. So I would say that is it fair? Depends. The condo manager, typically those services are not covered under the management contract, so they're billable above and beyond the contract. They certainly should be billed above and beyond the contract. It can be a time-consuming thing, and a condominium manager, it's difficult for them to do that and perform all of the regular duties for the condo corporation. So billable above and beyond. In most cases, I think it's better to bring in a separate designate. And the reason I say that is because the property manager's focus can then be on just communicating with unit owners, and the designate's doing everything else related to that process. The designate even can be designated to communicate directly with board of directors, with the property manager in there. So that's the best solution that I've seen.
The only thing I'll add to it is a lot of times talk to your auditor. Sometimes the auditor will take on that designate role if they want. Different people have different opinions on it, but almost every single auditor can do the legwork for you, if nothing else. So they'll be able to go look at the defects, whether or not they're repaired, provide recommendations to the designate on whether or not they think they have met, well, I guess what they originally thought was a defect in the first place. It also helps if you have situations where there is going to be technical expertise that likely the designate, no matter who it is, are going to have. So you'll be able to use your auditor for those kind of situations too. So if you get them into the right period of time, they can even set up so that they just go every 90 days and go follow up during that process for you. So we can keep those deadlines as you go, and they just provide recommendations to the designate to say, here's everything we feel you can sign off on, and then they can make the decision whether or not there's something that they feel strongly that shouldn't be or that should not be. But yeah, those services are usually there for the designate as well.
Yeah. Excellent. So I did want to give one more shout out. That's to Justin Brunn, who helped me kind of arrange some things in advance. And again, John Dozois at IT Condo for all of your help beforehand and today. Thank you very much, John. Christy, thank you so much for being here. I know how valuable your time is and how much you have on your plate. Anytime that you come and help us out. So we really appreciate it. Your insight and your experience. And Steve, the same. Thanks so much for your time. I know for both of you, these are issues, performance audit and Tarion, that are near and dear to your heart. You feel strongly about.
No, thanks for having us, Mark.
Yeah, thank you so much. And it's actually an honor to be part of your inaugural
Yeah,
podcast. So
that's
thank
right.
you for that.
And you survived it.
Yes.
Excellent. So now we'll hope that everybody can survive their drives home. I know we were all late getting here today, later than we wanted to be because the streets and the driving was just crazy, but to be expected, and hopefully things will get cleaned up in the next couple of days. Hockey will be all back on again, and the important game coming up soon
Thursday.
As well. Is it Thursday?
Yeah, Thursday night.
Thursday night. All right. Yeah, we'll be looking forward to that one. I'm sure most TV sets in Canada will be occupied with that. Thank you both so much, and we'll look forward to having you on again at some point down the road. Thanks, everybody who was able to spend time in joining us today. Have a great day. Have a great week.